lord, today can grant me an accommodation, my lord, today.
11 is 2019. Please wait till the matter is called. In 2019 matter, they are not adjourning.
I have not been able to.
Unless it is called. We'll have to look into the records and then.
I have a query in item number 24 and 43, my lord. 24, my lord, I could not, my lord, contact with the my lord, petitioner. My lord. Paying for the adjournment, my lord.
24.
24, my lord.
24 can be adjourned. What says it represented on the clear
Item 43 of
statement. Matters to adjourn today. List on. Give a date after 2 weeks.
There is another item. Item 43 is also there.
43.
It's a hearing matter, my lord. It's a part head, my lord. I'm sorry to say, my lord, I could not take preparation, my lord, yesterday, my lord. Any date in the
43 is 2017.
It's a part head matter, my lord. Submissions are already made. Not part head, my lord. It is not some hearings were conducted, my lord, on earlier occasion. My lord. In the next week, my lord.
No, not next week. Thursday we can take it up.
My lord.
Thursday, 43.
May I please, your lordship? I beg to mention item number 6, your lordship. Engaged counsel L. Mohan, your lordship, he has been appointed as public prosecutor, your lordship.
So whatever is 2019 matters, we are not adjourning unless we call the records.
Okay, your lordship.
Then the matter is for no adjournment 2019 matters.
May it please, my lords, pay for listing of a matter, ma'am.
Listing here to the court master.
Briefly of that. My pleasure, lordship. Item number 1. The engaged advocate is not in position to appear due to waterlogging, lordship.
But still, we'll have to call it. 2019 matters, we are not adjourning without looking at the record.
Lordship, due to waterlogging, lordship.
We understand, but we nonetheless see the records, we are not adjourning.
Lordship.
Yes.
Lordship similar prayer, lordship, 29, lordship.
Item
29.
20 is 2017 matter. Unless we call it, we are not adjourning.
May I please, your lordship, Lord, with regard to item 34, because Lord, in this case, I filed one IA, Lord. So that is probably that is not kept in the record, Lord. So if I may be permitted to without inquiry. Obliged. And if it is not
IA.
IA, my lord.
IA will not come like that. It has to be listed. What is the IA?
There is an IA for my lord substitution, my lord. And if not substitution, that is striking of my lord. Petition number 1 died, my lord. So I filed an IA and encroaching the death certificate. Item 34.
Make it Wednesday. Yes.
What is it?
Make it Wednesday. Along with IA file. Huh? Item
Obliged.
29. Item number 34. Okay. Yes.
May I please, sir? I beg to mention for item number 48 and 49, your lordship.
40.
Supplementary 48 and 49. It's on admission, my lord. But my lord, it has to become on motion column, my lordship. There is no interim also, my lordship.
It's okay, we'll take it up.
So, after motion.
We'll take it up, don't worry.
Master, please.
May it please, your lordship. Item number 42, lordship. Although our name has been shown, lordship, the brief has been taken away by the petitioner's son, lordship. So
That we don't know. If you are not there, we dismiss it for default.
then maybe strike off, lord.
We can't do it. You will have to file an application. Have you filed an application?
No, lord.
Then we can't do it.
Simple. I like to mention for item number 31, your lordship. It may be upgraded, your lordship.
31.
Item 31.
You want an upgradation?
I will.
Okay.
My lord, I am waiting for a mention, my lord. I am having item number 26, your lordship.
20.
26, admission matter by, I want to do it today, my lord. So may I try to get it updated for some time?
It
Updated
will come in the motion admission column only. It can't be, it is first item.
for upgradation, my lordship would be, I supposed to do it.
Before motion, you want your admission to be
No,
done.
no, no, not before, after exhausting motion, my lord.
First, in your
Please read the cause list. Please read the cause list. Your matter is first in the admission column.
Thanks.
Daily list item 1 for motion.
Okay, we take it up on Wednesday. Okay, both sides are represented on the plan made by learned counsel for the petitioner based on 22, 4.
22.
Highly opposed.
Item 2 for motion.
My pleader, Lordship.
Yes.
Lordship, I am sorry to say, Lordship, no, I am unable to prepare today, Lordship. Today morning, when I reached Gauhati.
Okay, make Friday then. This matter. Friday would be 24.
Today will-
Okay.
Friday.
Friday. So, one small frame regarding the item number 16, Mr. B. Chaudhary informed
Let
me,
it come.
this is hospital matter.
Let it come.
Yes, obviously.
Item 3 for motion.
Notice issue.
Yes.
In this case, this honorable court, granted interim, filed order 4/11/2019. Also, record already received,
Yes.
Pick the matter for, admission,
We'll take it up right now.
Impute, final order, kindly see page 57. The petitioner declared as foreigner,
But
though, the petitioner submitted,
to your projected parents.
my
Your first voter list is of 2006 and then 2009. There's a long gap of many years.
But, the grandfather of the petitioners, kindly see, page 17, page exhibit 1. It is the 66 voter list,
No, we don't know that he is the grandfather. How are you showing that he is the grandfather? How are you connecting? That is the question.
And Audhir Singh Sinha is the grandfather, Next, kindly see page 29, It's a voter list of 2005. Father's name is Oviram Sinha, and his father, Audhir Sinha. And the name of the petitioner is also reflected, Benubala Sinha, serial number 841, and son, daughter of Oviram Sinha.
So except for voter list, you don't have anything to connect you to your projected parents.
But it was not exhibited, before the tribunal.
Which document?
Kindly see page 26, it is the revenue paying receipt, Malad. Malad. Another also Malad certificate, kindly see page 37, Malad. It is the school certificate, Malad, in case of Obiram Sinha, father of the petitioner, issued as per register Malad, his date of birth 3/1/1958 and leaving the school on 31/12/1971. No, my lord, it is not, my lord, but exhibited before the, my lord, tribunal, my lord.
Yes.
And my lord, her, my lord, name in the portal is continuously in the, up to, my lord, 2019, my lord. Since 2009 to 2019. 2005 to 2019, my lord. Learned Tribunal, my lord, misbelieved the, my lord, exhibit 1, my lord, only because of some, my lord, age discrepancies, my lord.
No, you forget about the age discrepancy. We will not be serious about it, but there must be some document to prove it. Your voter since when to when?
My lord,
Your voter since which year to which year?
my lord, 2005 to 2019, my lord. And the same, my lord, 2045, my lord. Page 29.
Then, please, explain two things to us. You just showed your, school certificate.
Full certificate, my lord.
No, your birth certificate.
It is the, my lord, birth certificate of my son, my lord. I have annexed, my lord, but it is not, it was also exhibited, my lord. Page 47, my lord.
Just a moment. This page 39 is your document?
Page 39, my lord. It is the school certificate, my lord.
Yes. Please statement that this is incorrect? No. Any statement in the repetition that this document is incorrect? Obviously, if it is incorrect, you will not annex. Correct.
My lord.
Now, if she's born in 91, how can she be a voter in?
2005.
No, 14. One, 14. things do not match. That's a difficulty. Please come to this document, page 46.
46, it's a Panchayat certificate.
Yes. You got married on 4/7/2007.
My lord.
Next page, page 47, your child was born on 31/1/2006. Just shows the voters list, of the exhibited voters list.
Executive voter list, my lord.
First is 1966.
First is Exhibit 1, 1966. And second, my lord, voter list, page 31.
That's not good.
Odir Sinha and Malati Sinha.
Second is
Yeah.
2009.
2009.
Which page?
Page 31, my lord.
With the
Exhibit 3, my lord, voter identity card of the my lord Odir Sinha, my lord,
yes.
grandfather.
Then exhibit
Then
4,
Exhibit 4, my lord, page 33, my lord.
P3.
The petitioner's name, my lord, along with his father, my lord, included in the voter list 2009.
But you see, the picture is not complete. 2007, you got married.
My lord.
You could not have been with your father's, in the father's voter list. The inquiry date is very crucial. Your inquiry started in 2007. And in 2009, your name comes in your mother's parental home. You should be living with your husband because in 2006, you had a child, 2008, you had a child. You could not be in your parental family.
Regarding relationship with the grandfather and father, my lord, it is established, my lord.
How many witnesses you examined?
Only the petitioner, my lord.
So
I
the
think-
family members came, and according to this 2009, page 34, what is this?
Page 34.
You have at least two brothers.
Abhiram Singh, Kananwati Singh, and Ashok Kumar Singh.
And Mithila Singh.
Mithila Singh is the, my lord, your
Come to,
elder daughter.
they did not come to support you.
Ashok Kumar Singh is the elder brother, my lord.
And then come to page 59. In 59, page 59, down below, you say, father has one younger brother, Pushpa Sinha, staying at the village, and he has four sisters. Two sisters are married, so proceeding as brothers and sisters. Elder brother is Ashok Kumar Sinha, staying at village Bukoi. And in this, your marriage is in 2005. In this paragraph, page
My
59.
lord. Ashok got married from her same village in the year 2005.
There are six brothers and sisters. All of them are not there together.
Not there, my lord. humble me, remand
That's
the
why the
matter to
doubt
the,
is created. You are showing that from the voters list, father and grandfather is established. Now you showed uh, what you call a revenue receipt, but you don't have land.
my lord.
So the revenue receipt is for which land? That's not explained. You have 6 brothers and sisters, they are not together. You have not also disclosed about them in the written statement. And therefore, there's a doubt that this is a borrowed document. And that is why the mismatch. You see, if you have a school certificate, then you know the date of birth. So therefore, the other mistakes could not have come.
My lord.
And normally in a school admission, I don't even remember, but I am told that when I took admission in the school, my parents gave my date of birth. So definitely my parents will not give a wrong date of birth. There is a presumption. But I'm not sure of it. In this particular case, who gave that date? And then
91.
the incorrect dates. You see, a 28-year-old lady, she will not make mistakes of 5 years in her date of birth. Because 2007, the reference is registered. So then she will not make a mistake of 5 years. 1 or 2 years we can omit. There is discrepancy in the age of your grandfather, we are omitting it. We are not even asking you questions on that. But the problem is that unless you have the entire family together, it's very difficult to understand who is the younger brother, who is the other brothers.
My lord, it is not exhibited, my lord, kindly say, my lord, see 2009 voter list, 2 voter list exhibited, my lord, regarding grandfather and mother, and second, my lord, with father, my lord. But it's not a continuous voter list, my lord. Page 32 and page 34, my lord. Same center, my lord.
So there is difficulty in that also. If you are comparing page 32 and 34,
My lord.
can you come to page 32?
It is a grandfather.
I felt better in vernacular. You see, 32, Ajit Singh,
Singha and Malati
is in
Singha.
house number 166. And the other voters
My lord.
are at house number 131.
My lord. Subsequently, my lord shifted the residence, my lord,
No,
within
no,
the
no.
village,
You
my lord,
see,
within the same locality.
grandfathers are aged 84 and 77. Normally in our system, they will not be staying alone. If they are the members of the same family. 84 and 77 is not an age to live alone. Then what about 6 brothers? How about other brothers? Your father also had brothers. There's no this at all. Father is alive.
Alive, my lord.
He also did not come to your aid. Yes, Ms. Verma, what do you have to say?
Lordship, the first 2 voters list of 66 and 70 is of the grandparents' lordship. And after that, 2005, the father's name appears for the first time at the age of 48 years. The continuous stay is also not there, and there's the link with the father and the grandfather, that is also missing because of change of residence, lordship. And this voters list at page 30 is an extract copy, which is not an admissible piece of evidence, lordship.
Hmm?
page 30, Lordship, Annexure
Zero.
3. This is an extra copy, neither a certified copy. So this is not an admissible piece of evidence, Lordship. Then again, 2009, there are two voters list, which he has just shown, Lordship. Grandfather and the family. And as Lordship has pointed out, after getting married, her name still figures with her father. Usually, the voters list which come forward are with the husband, Lordship. Then the school certificates, both which have not been exhibited, neither proved, Lordship. And again, the birth certificate which Lordship has seen, the discrepancy, the child coming before the marriage, Lordship. And the panchayat certificate, Lordship, this is again not an admissible piece of evidence, Lordship. This was only for the purpose of NRC and which has not been notified till date.
Because once the family can be shown together, then perhaps
It
you
is
can
not
spend the
together anywhere, and there are only 66, 70. After 70, the grandparents come in again at 2009. In between 2009 and 70, there is no voters list, either of the grandparents or the family together. Then there's one of 2019 where the family again comes together, Lordship. 2019 shows only the name of the the petitioner, Lordship. 19, page 35. If Lordship comes to page 35, the petitioner's name figures here as a single voter list. Page 35, Lordship.
with father.
Yes, but the husband's name is not there, the other siblings are not there, she has 6 siblings. So even in the main voter list, which at page 33, only 2 sons' names figure. The others' names are not there, Lordship. And in the opinion, it's
Which page is that panchayat certificate?
Lordship, that is a page
46.
Lordship, the other thing is, which has come out in the opinion, Lordship, it says, Proceeding could not prove her linkage with her father at all because in her name appears for the first time only in an extract copy of the voters list in the year 2009, which I've already submitted before Lordship. And even regarding the grandfather Lordship, it says his voter ID is of 2013. That means he has not been in Assam, not living as a continuous citizen all through because the voters list are missing and his name appeared after a long gap of 43 years in the voters list of 2009. After 66-70, it appears again only in the year 2009. 70 is, I saw 70, I think.
Not proved, madam.
Not proved, not proved.
Not proved, madam.
So that was not exhibited, so 66 and then it comes after. So on this ground that they have not been in the soil of Assam for continuously, Lordship, that ground is enough for dismissal of this petition, Lordship. Continuous stay has to be proved and just bringing in the voters list of few years does not grant them citizenship. At page 62, the member has very clearly stated, Lordship, that Proceedee produced a voter identity card of Adhir Singh. Relation's name is Godhur Singh. He is 87 years old in 2013, which proves that if he is not living permanently in Assam, if he would have been a permanent resident, his name ought to have appeared in voters list for other years too. Moreover, Proceedee's father, Adhir Singh, and the voter Adhir Chandra Singh, son of, may not be the same in one person. And since no voters list has been produced of 1966 and 2009 to check the names, it raises a doubt, Lordship, whether regarding the genuineness of the voters list submitted. Not a single document to show her linkage with her father or her 6 siblings, Lordship.
मला त्या planet मला tribunal मला doubt मला regarding मला citizenship due to non-submission of मला continuous voter list मला.
Yes.
Well, it is not exhibited by the proceeding, my lord. But my humble prayer, my lord, last chance may be given to the petitioner, my lord, to exhibit the continuous voter list, my lord.
Sir, opinion. Or-
19. My lord. Immediately after, my lord, I filed before this honorable court, my lord. Approach before this honorable court, my lord.
The surveyor jurisdiction, we can't do it. We can't examine documents. Please come to your index page. Even now, in this repetition, you have only annexed two extra documents, which is 1970 and 2005.
My lord.
Then also the continuous stay is not there. In your index page, serial number 3 is 1970 to 2005. These are the two documents.
My lord.
Still the continuous stay is not there. 1970 to 2005 would be 35 years. Still not explained. Even before this court, you have not brought those additional documents. If they are reserving the orders, but Mr. K.R. Patgiri learned also for the petitioner and also for the respondent. Yes, I can put it, order reservation.
All right.
For motion, item 4.
None.
Last date also not yet, your lordship.
Today, because of
Water lordship.
water logging, take it up day after tomorrow. This none appears on call for the petitioner. Petitioner, however, all the respondents are represented. Next para. when the matter was previously registered on 23/3/2026, the petitioner was absent on call. And this court had made it clear that if the petitioner remains absent and unrepresented on the next date of listing, adverse orders shall follow. Nonetheless, one. For answer this, the matter again is again adjourned. If the petitioner remains absent and unrepresented on the next date of listing, adverse orders would follow. But it is from 22/4/2026.
For motion, item 5.
Okay. None appears on call for the appellant, for the petitioner. All the respondents are presented. For ends of justice, the magistrate general today. This again on. May.
11th of May.
Lordship, our presence may be recorded.
We are recording this. It's not the responding secretary.
Item 6.
May please the Lordship. Your Lordship, kindly consider me be adjourned as engaged counsel L. Mohan has been appointed as public prosecutor, Your Lordship.
Okay. Okay. It is presented on the pyramid panel transfer to the petition. The petitioner is not today. List again on. Give it after 2 weeks.
Oblige, Your Lordship.
Item 7.
Petitioner is unrepresented on call. How all the respondents are present. For injured respondents, may get that if the petitioner remains absent on the next date of listing, adverse orders would follow. This again on.
Item 8.
Yes.
Lordship, in item number 7, the matter may kindly passable for the day. My senior could not come due to the flood situation in the city. So the matter will be passable.
Both sides of the call. Both sides are represented on the pyramid panel cost for the petitioner. It happens to be based on.
Obliged.
None. For the petitioner appears on call. All the respondents are represented. The petitioner was absent when the matter was previously listed. Next up, for ends of justice, the matter shall be adjourned today. It is made clear that if the petitioner remains absent on the next date of listing, adverse orders will follow. List again on
11th of May. Item 9.
May I please, your lordship?
yes.
On last occasion, my lord, this honorable court directed the petitioner, my lord, to appear before the superintendent of police, Kolkata, my lord, and accordingly, the present petitioner appeared before the ST, my lord. So matter may be come up for admission or hearing column, my lord.
If you are ready.
Order was passed on 8/11/19. Order was passed on 8/11/19, my lord. This
That's
honorable.
okay. If it's a cold matter, we can take it up for hearing.
Actually, my lord, it's earlier occasion, one Bikedas had appeared in this matter, my lord. Today morning, I have received the file, my lord. So I maybe allow some time, my lord, to prepare myself, my lord. That's my humble prayer before your lordship.
Yes, Norma, You just take this record
Yes, Lord.
and look into this. Here. You have a copy of the writ petition?
Yes, Lordship.
Page 88.
Additional written statement.
Yes, paragraph 5.
Yes, Lordship.
The name of the proceeding is Imtaz Ali. And paragraph 5 says the second part, his own name is Darvesh Ali. Darvesh Ali is father's name. The written statement is wrong.
But in this, maybe it may be a typographical error. In the starting, the first part, he says
No,
state
no,
of
it
affairs.
makes the written statement wrong.
Yes, Lordship.
Now come to page 92. Now he says his father's name is Darvesh Ali.
Son of, yes, Lordship. Third paragraph also says that my father's name is Darvesh Ali, Lordship.
Exactly. It makes the written statement incorrect.
Lordship, at page 95, Lordship will see in the cross, he says he's forgotten his mother's name.
The problem, that's why we are trying to show it to you. I was just missing that.
Yes, 88, my lord, it might be typographical error, my lord.
No, we
That-
don't know. We are not saying anything. We are not holding any opinion. We are just telling Ms. Verma she can make a note and then make an argument. We'll list it for admission. Lordship, just. We have the. Pursuant to the others past earlier, the records of the tribunal is received, which requires examination. Accordingly, court is in time to issue notice of motion returnable on so and so. This will the admission follow this one.
Item 10 for motion.
Deeply obliged.
Oh.
My lord, the matter may be adjourned for the day, my lord.
In this also, open to page 20.
20, Lordship. I'm at page 20, Lordship.
20.
Yes, Lordship.
Down to about 7 lines from below. Exhibit A and Exhibit B, on the strength of which she claims to be an Indian, is absolutely self-contracted in as much as Remand Nessa, whom she is projected to be her aunt, is shown as wife of the projected father. Something is very wrong.
Lordship, can I just ask, Lordship's petition is from which district, Lordship? Mine is from Kamrup Rural. The names are so familiar and same.
5797.
Lordship is.
5797. This is from FT Bogota.
I have a different petition, but with the same name because of, Lordship, I'll just take it down. This is right about it. This is the wrong file today.
Give her an
From-
extra copy.
My lord,
By tomorrow, give her an extra copy.
yes, my lord.
Page 20, Lordship, I'll take it down and put it up in the petition, Lordship.
Page 20, Exhibit AB,
Okay,
he projects someone as the aunt, and tribunal finds that she is the mother.
okay. We'll note it down, Lordship.
That's why these exhibits, it was again, all these exhibits were scrutinized to find that the evidence of DW1, DW2, and here again, page 22 is a discussion on DW2. Yes, he deposed that Sophia Khatun is the sister, does not know the name of the husband. That's why
We'll note it down, Lordship.
the link with the projected father had snapped. Okay, both sides are represented, same order, both sides are represented. Question to order passed away, the records will tribunal receipt. Requires examination. What is intent issue? Notice because I'm law. Extra copy, one extra copy of the petition was served on the donor standing up to the FT and border matters in 2 days based on such.
Right.
Take her number and give it to her tomorrow.
For motion, items 11, 12, and 13.
Item 13 will have to be in the petition. 13 to Nayamata. You were sitting at the
Yes.
Um, my lord, please use my lord.
My lord, I was not able to prepare fully, my lord, with the matter. I was not able to prepare fully with the matter, my lord. Otherwise, my lord, what I could see in the morning, my lord, it they had submitted, my lord.
So that is why. But please,
In this case, you have a copy of this petition.
I have of 11 and 12, 13 I don't have lordship,
First item is
11.
11 lordship.
Uh, you have to examine here, come to page 63.
Yes, lordship.
Exhibit 1 is a reference in paragraph 6A,
Paragraph 6, yes, lordship.
and the corresponding document is page 29. And this is a very important point because you see, the court had discarded this page 29 certificate on the ground that the entry into India and the registration is within 10 months, which can't happen under 51A. That is, I think, 7 years. I could not read the date of entry here at page 29.
Date of entry, lordship is not there.
Yes, Mr. Day, have you seen the date? And tell us the date.
My lord, what I was being told, my lord, is that over the telephone, my lord, that it may be before 1956 they have entered sometime, but the petition, but they were refugees, my lord. Otherwise, my lord, that's what they have told me.
That will
Also.
not help you. That goes against you. You say 1956.
Before 56, my lord, that is what I was being told over the, my lord.
And from 66 lordship, we have the name in the voters list.
You see, that could not have happened before 56 year entry could not have been into the country. The reason is that this Citizenship Act 1955 was notified only on 30 December 1955. So therefore, if your entry was before 55, it could not have been registered under Citizenship Act. It was not there. Your refugee certificate would have been under different law. The refugee certificate is not before us.
My lord.
Refugee certificate has not been examined. It has not been shown. And the tribunal gives a finding of 10 months.
my lord.
Destroys your case. Because the corresponding, what do you call, the documents, there are mismatch. Or the other documents.
And that registration certificate was obtained when he was 34 years old.
No, that is not our concern, because
Yes,
once
sir.
he is registered as an Indian. But that certificate was demolished by the tribunal on that ground. The entry into India. When Mr. Desai came into India before 55. Before 55 could not have been.
Before 56, my lord, that.
Before 56 is 55. 55, 30 December is the date when the Citizenship Act comes into force.
But I'll take it again, my lord, with them, and in the morning I could not take it again. My lord will give me this.
You become some, what do you call, okay, let me not comment. That is the document you'll have to examine. This is the missing link. It takes away all this, it demolishes all these 3 cases. Is that this one? We'll fix it for admission.
Please, Lordship.
Also, to
Item 13.
Pursuant to order passed on the records of the tribunal is received, all which requires examination. Accordingly, issue notice of motion, returnable on so and so. List in the admission column on so and so. Date, he will give it to you. Date, he will give it. Dates, please correct it later. You'll have to adjust and then give.
Lordship, item 13, I would request for a petition.
I'll give it, I'll give it.
30.
I'll give it.
It's beyond
In item 13, we just add extra copies of the red page files are from the land, standing for the FT and border matters within 2 days.
Item 14,
Deeply obliged, my lord.
But they can come.
item 14.
May it please, your Lordship.
Yes, Mr. Pratap.
Lordship, as per last order dated 1/6/2020, this honorable court has observed leave for motion again after 3 weeks on a date to be fixed by registry, as we propose to examine the case records at the first instance. And the Lordship case record has received.
Yes.
Lordship, this is an the impugned judgment was passed ex parte against the petitioner, my lord. He is a illiterate lady, my lord, does not know the legal intricacies, my lord. What had happened in this case, Lordship, after receipt of, my lord, notice from the tribunal, my lord, the petitioner, my lord, appeared.
You have the original exhibit of this page 21. Do you have the original of this?
Lordship, that I could not, my lord, exhibited, my lord, because, my lord, on, my lord, 21/1/2008.
Question, we are asking you whether you have the original of it.
Yes, the original I have, my lord.
Show it to us, please. Show it to Ms. Verma first, then we'll look into it.
Like in the other certificate which Lordship just needs to answer. Look of entry is not because. No, it's about 56 documents.
Lordship, against my uncle also, there is another proceeding was going on, and he exhibited this document, and subsequently, my lord, he was declared not foreigner.
Which page is that?
25.
That judgment, Lordship, I have an page 25. It starts from page 25. And Lordship will get the relevant portion at page 26, para 5, point number 5.
This until and the procedure has been integrated into voting space. Some documents are-
Yes, I have checked it. Our certificate is
Which is your opinion? Ex parte opinion, where is that?
Lordship.
Where is the ex parte opinion?
Expert opinion, Lordship will, it starts from page 18. My lord, may kindly see page 19. Page 19, my lord, paragraph number 9A. PW1, Sri Amos Tepe is the Sorkari Gaopuram number 1 Podumoni Gaon. This witness expressed his inability to say whether the OP is an Indian citizen or not. PW2, Mohammad Sabir Khan stated that he did not know the OP. Well, on that day, my lord, I was present, my lord. But my advocate was not present, my lord. So they were not cross-examined. And accordingly, they were discharged. Subsequently, my lord, PW3, my lord, on that day also, my lord, 9B, my lord, PW3, Sri Seniramnath SI Border is the EO in the instant case. PW3 went to the Khonikor Gaon and made the OP so and so in-house. On being asked by the PW3, OP told him that, well, he has submitted his inquiry report, and that was exhibited. And on that was also, he was also not cross-examined, my lord, because my lord, my advocate was not present on that day, though I was present, my lord. I have,
Which date? What is the date?
my lord, 13/05/2008, my lord. My lord, may kindly see page 16. Page 16, my lord. Order I have enclosed, my lord. Opposite party is present. The inquiry officer is also present. He was examined and discharged for not cross-examining him, fixing so and so for evidence of opposite party. Opposite party is directed to bring her witnesses. First we did fine. Moving is very.
approaching this court after 10 years. You are default.
Lordship. What had happened, Lordship,
Unexplained.
on 10/7/2000, my lord, Lordship, on 10/7/2008, my lord, when the matter was fixed for evidence of petitioner, my lord, petitioner informed her counsel about her inability to appear before the tribunal, along with her witness, as she was suffering from rheumatic pain, restricting her movement. And my lord, thereafter, my lord, on that day onwards, my lord, default was, my lord. I admit, my lord, I have been told, my lord, that I will be intimated, and that was my mistake, my lord. Since then, my lord, I did not appear, my lord.
From 10 to 19, 9 years.
Thereafter, my lord, what had happened, my lord, it was, judgment was passed by, my lord, Tribunal of Golaghat, my lord. And subsequently, my lord, for 5 districts, my lord, there was presently on only one, my lord, Foreigners Tribunal, that is a Jorhat, my lord. It was transferred to Jorhat, my lord. And when, my lord, I have been inquired by police, my lord, that was on, my lord, 6/6/2019, my lord, when the police visited my place, my lord, in my absence, my lord. On that day, my lord, I came to know about the, my lord, outcome of this proceeding, my lord. Thereafter, my lord, certified copy was obtained on 28/06/2019, and it was filed thereafter, my lord.
Therefore, 9 years, there's no explanation. You don't go to your counsel, you expect the home delivery of orders.
That was
You
my
got this
mistake.
home delivery, you came,
That-
the
that-
police came and gave you the delivery of orders.
That is true, my lord. That is my mistake, my lord. I have committed, my lord.
But then it will be dismissed on that count around 9 years. You
Uh,
don't find any
no.
logical reason.
But my lord may kindly see, my lord, if I, my lord, get a chance, my lord, I can definitely prove my citizenship, because, my lord, my uncle, my
That's
lord.
sufficient time. You see, this order was not passed in a hurry. This order sheet here shows that you are giving sufficient adjournments.
3 years prior to passing of the order. So it started in 2007.
Yes, 2007,
Yes.
2007 to 2010.
And it was
Fine.
passed on 2010.
Enough time, opportunity, everything was granted.
Lordship, that was my mistake, my lord, because it was, my lord, it was my mistake, my lord. I did not appear. But, my lord, may kindly appreciate one thing, my lord. When, my lord, the witnesses were examined, my lord, my counsel was not present, my lord. Therefore, my lord, they were not examined, my lord. And, my lord, PW1,
No, you see, the tribunal only merely closed that cross-examination. You could have asked for a revival of the cross-examination. You never did.
yes, that was there, my lord. But I could not, my lord. Therefore, my lord, my humble prayer, my lord, I may be given a chance, my lord.
Your law is in default. In 2008 only, you know that your law is in default. And still you did not take any appropriate steps. You don't find this in your order to be bad.
Actually, my lord, I was not properly instructed, my lord. I'm a very illiterate lady, man. So, my lord may give me a chance, my lord. Because my uncle, my lord, he exhibited that document and he was declared, my lord, Indian, my lord.
Then you see, that's the whole problem.
And, my lord, though my lord, there is a delay on my part. But, my lord, may kindly see, my lord, PW1. My lord, he expressed his inability to say whether the OP is an Indian citizen or not.
That's the whole problem. We started the question asking you questions only from that document, no other document.
Yes, sir.
That's how we started. Come to page 25.
Yes, my lord.
This opinion is of 26, 2017.
Yes.
You realize that you have a good document and then you close this.
No, it was passed subsequently, my lord, because, my lord, my uncle, my lord, he participated in the proceeding, my lord, and he has exhibited that document.
So you waited for the result. You were sitting on the fence.
My lord, I admit, my
See,
lord, that
there's
was my
another thing.
mistake,
We
my lord.
showed you a part of this page 25. Come to the second line of page 25. Case number FTG 408 of 2007. Your case is 409 of 2007. So both of you know that the proceedings are against you in the same tribunal 408, 409. You allowed the default to continue. Then you become wise after 2017.
My lord, that is there, my lord. My lord, only my respectful prayer is that, my lord, that's because, my lord,
That shows how this order is wrong. Why should we interpret this?
my lord, I have enclosed, my lord, the voter list of, my lord, though it was not exhibited, my lord. Voter list of, my lord, that page 22, my lord. It was of 1965, my lord. My lord, Umesh Ram Suklovaidya, my lord. Mirendra Suklovaidya, my father, my lord. The Umesh, that is my lord, my grandfather, my lord. Saya Suklovaidya, my mother, my lord. My lord, within a specific time frame, my lord, I may be given a chance, my lord. And my lord, make also see, my lord, page 23, my lord.
Page 23 doesn't help you because of page 24.
I am just relying on, my lord, showing my relationship, my lord.
We understand.
Only
but
to that
up to
extent.
Page 24. That destroys your page 23. Yes, Ms. Verma. It is Ajay.
You also consider the kind of delay in activities will not for people. It will not take further time. That's the thing.
Lord, delay,
Almost 19 years out. And
My lord,
the document which is there, that is not exhibited of 55. Enough time, lost it 3 years, more than 3 years, the proceedings took place.
my lord may give me a direction, my lord, to appear before the tribunal, my lord. And within a specific date, my lord, I will not make a single default, my lord. And within a specific time frame, my lord, if the matter may be, my lord, decided afresh, my lord.
Okay, we'll pass orders. We'll get to know tomorrow morning. may not be able to dictate it today.
Obliged.
Item 15.
Lordship, here I want to pray for adjournment of the matter, Lordship, on behalf of our own Lordship.
Both sides are represented. On behalf of the learned counsel for the petitioner, prayer for adjournment is made. Next. Assuming that the records of the tribunal is received, or it requires examination. Or the court is inclined to issue notice, return over on for this. List the matter in the admission column on. Okay.
Item 16.
You're praying for adjournment?
Yes, Lordship.
They're passing the same order, fixing it for admission
Yes.
on same day.
Lordship.
Item 17.
May I please, your lordships? Records received, lordships. Let the matter posted for admission hearing, lordship, from date revision. In this case, only three documents consider, others discarded also.
So that you also see the earlier order where you paid for adjournment for the record you received even in 9/10/2020.
Lordships.
Then also records were there.
Yes,
But
lord.
you paid for an adjournment and therefore
In this case, lordship will find only exhibit 1, 2, 3 considered, other only discussion, lordship, not considered. So the impediment is not sustainable, lordship. And apart from that, earlier also declared as an Indian citizen, but order is not available, so rehearing was started in terms of the orders of this whole court stated in the impugned opinion, lordships. But only one date I find only exhibited documents considered, but consider only 3 documents, other not considered. And oral evidence, non-considered oral evidence.
no, there is a discussion. Page 66, there is a discussion. At page 66, there is a discussion.
Page 62.
66, para 20.
Only lordship will find 1, 2, 3.
Please read it. We have,
Lordship.
unless we read it, we will not say that. Please read that paragraph.
Page 16, lordship, page 65. Out of 9 documents filed by the proceedee, there are 3 documents indicate relationship between the proceedee and the Talebali could be established.
No. Page 66, para 20.
Therefore, if the above exhibit documents, exhibit 1, 2, 3 are excluded, there is no linkage with the projected father Talebali. Thus, having regard to the discussions made above, it apparent that proceedee could not prove she was the daughter of Talebali, whom she claimed to be her father. The proceedee other exhibit 4, 5, 6, it is seen that there is no any linkage to him. In such circumstances, the tribunal of the uninstituted view that the narrative presented by the proceedee suffers material omissions and contradictions, rendering the same wholly improbable. Therefore, the proceedee has failed to discharge the burden under Section 9 of the Foreigners Act. So, my father, lordship, evidence, lordships, oral evidence not considered, DW3 neighbor not considered, my evidence, the oral evidence, non-considered oral evidence also not sustainable law, lordship.
Correct.
Lordship judgment and this all courts
so many judgments are, if my lordship allow me to place the same.
Oral evidence is no evidence at all.
No, lordship, that is required to be considered. Since why required for consideration? Since I appeared, my evidence to be considered. Your lordship will find in for the Khatun case, lordship specifically stated. 2024 GLT. And another Jamila Khatun Basad, WBC number 8243 to 18, your lordship's ruling, lordship judgment. And that is the judgment of lordships.
This Remand has to go, there is no discussion. The evidence of DW2 has not even been referred to. We send you the records.
Yes, Lordship. Opinion, Lordship. As it is, Lordship, this is the second round of litigation. First round declared Indian, no order passed. High Court sent remanded it back for reconsideration from the argument stage. And then this is again Mr. Yes, Lordship.
Actually, not this case. Overall, all the cases, there is a direction, those are pending, someone retired in the meantime, that may be reopened, not case the second time, first time.
No,
No, this case, first time, because the
exactly that. That is why he came to the High Court, he got the order to start it afresh. It's the second round then. I didn't say the proposition. Representative is. No, it is a theory. It is this theory. Because it's definitely particularly a key approval of the district. That's on the specific issue, Lordship may remand it back, Lordship, on this specific issue. And let the outcome be decided, Lordship. Let the opinion member take a call again, Lordship.
In view of the order of remand, which is proposed to be passed, there's no point in discussing the evidence and the written statement and evidence of in this order. Next para, it suffice to mention that initially by an opinion dated 10/4/2017, passed in this case, the petitioner was declared to be not a foreigner. However, during investigation, it was found that there was no order in the record and no witnesses were examined by the learned tribunal. Accordingly, pursuant to order dated 22/6/2018, passed by this court, in which was that writ petition? You have a number of that writ petition, no?
Is that paragraph 5 is in, there's a mention on page 63. It's the memo number.
It's only memo
Memo
number.
number, not the case number.
Passed in a writ petition within bracket. The writ petition number is not disclosed in the impugn opinion, bracket 4, comma, the a fresh trial was ordered. So resultantly, comma, the present case was revived. Full stop. Next part. The petitioner had filed his written statement and her written statement, and she examined herself as OPW1 by filing evidence on affidavit on 2/4/2016. He has also examined her projected father, comma, Mohammed MD, Tayyab TAYAB, Tarak Tayyab Ali, as OPW3, W2 on 2/4/2016. Thereafter, on 5/7/2016, on 13/7/2016, the petitioner also examined one Akhtar Ali, AKTAR, Akhtar Ali, as the OPW3 of the, though the witnesses were present as per order dated 24/8/2016, comma, OPW number 3 was examined by the learned tribunal and the matter was fixed for argument. Full stop. The evidence on affidavit by the OPW1, OPW2 and OPW3 is available at page 27 to 35 of the tribunal's records. Next one. It is surprising to note that in the impugn opinion dated 6/2019, there is no reference to the evidence of OPW2 and OPW3 or the examination of OPW3 by the learned tribunal. Full stop. Moreover, while the learned tribunal had referred to 9 exhibited documents, but the discussion was limited to Exhibit 1, Exhibit 2, and Exhibit 3. And without any discussion, the exhibit numbers 4, 5, and 6 were discarded as no linkage was noticed. However, there is no discussion on Exhibit 7, 8, and 9. Next. In view of the law, the court is of the considered opinion that the district although the learned standing counsel for the European border matters has made a submission to support the European opinion, saying the fact that there is no discussion on exhibit number 7, 8, and 9, and there is only one liner rejection of exhibit 4, 5, and 6, and no discussion on the evidence of PW or OPW. Two and 3, and also no discussion on the evidence of PW1, 7, except the exhibited documents, court is of the considered opinion that the Indian opinion is initiated for non-discussion of the evidence, all the evidence on record. The Indian opinion dated 861 is hereby set aside on the following terms. Matter is remanded back for a full detail before the learned member from a foreigners tribunal about India. The said learned tribunal is directed to discuss the evidence of all the 3 OPWs and also consider the documentary exhibits and thereafter pass fresh opinion in accordance with law. Next. The petitioner who's duly represented, petitioner namely so and so, who is duly represented by a learned counsel, was directed to appear before the said learned tribunal on or before 305 May 2026, and by producing a certified copy of the order, wait for the orders to be passed by the state tribunal. Next para. In the event the petitioner fails to appear within the time prescribed, it will be permissible for the said learned tribunal to treat the petitioner as absent on call and pass the appropriate orders in terms of directions given in this order. Next para. The registry shall send back the tribunal's records expeditiously, along with a copy of the order to be made a part of the record. Next part. The learned standing counsel for the border and active matters is requested to send a downloaded copy of this order to the Home and Political Department for Government of Assam to enable them to take a decision as to whether the state would require the members of the foreigners tribunals as well as the staff of the tribunals to be periodically. Kind of periodical training to update their skills. Next. Medicines. RTA out with the order of demand as indicated above. There shall be no order.
Oblige those.
We forgot something. Wanted an adjournment.
Now, lordship says other matters are fixing for admission. That's why I made submission, but I came with preparation.
Lordship, in this case, I am appearing on behalf of our day Lordship. Today he has not come, Lordship, due to water logging. So matter may be adjourned for 1 week, Lordship.
Okay, both sides are represented. The learned counsel to the petitioner pays for an adjournment. Next paragraph. Pursuant to others passed earlier, comma, the records of the traveler is received, comma, which requires examination. Accordingly, issue notice returnable on so and so. Next paragraph, list in the admission column on so and so. For me.
Oblige.
Item 19 for motion.
May I please, Lordship. My lord, may I kindly see page 11 is the voter list of 1966. Gauhati portion, page 12. In the name of Procedural, who is my father, and Basatan Nessa is my mother.
This is your written statement. Which page is your written
Page
statement?
31.
Have you given the date of death of your father?
No.
Date of death of the father is not there.
This. But it appears that in between 1966 and 1970, perhaps he has died, because in the voter list of 1970, petitioner's mother is there. Basatan Nessa's name is there.
I've seen that. That's why we are asking you that question.
When he died, that is not mentioned in WS clearly.
Then again, your brother also, after 1970, he also disappears.
Now, in 1970, mother's name is there.
Mother and Idris Ali is there. Ali is your brother.
Idris Ali.
But brother also vanishes after 1970. He is not there in the next voters list.
No, voter list
For him also, there is no statement in your written statement. What happened to your?
voter list are normally sought for how many persons it is sought for, accordingly they provide. So perhaps they applied only for Sher Ali, that is the present petitioner's name. So his father, Burmans are there. So in the voter list of 1970, his mother's name is there, father's name is not there. So it may be presumed that in between the 66 to 70, his father died. Now 85, that is page 15, operative portion page 16. Petitioner's name is there with father Koserali. Koserali. And the village is Karvalli,
Which is that page?
page 16.
16. But you know, there's a simple calculation. In 1985, this voters list, you are 35 years. That means you were born in 1950. You would attain the age of voting in 21. That is 1971.
Yes.
But from 71, your presence is not there till 85.
That is the matter of record. I cannot go beyond that. What is in the record, I am submitting accordingly. So these are, of course, common mistakes in names and voter lists. So here, what is written there, I am stating that. But
No,
your
we are-
lordship is,
we are not questioning you. We are asking you on behalf of the clients.
but here, lordship would see one thing. In the voter list of 1966, that is page 11, kindly see the village is Kharvalli. 66, village is Kharvalli. And in 70,
So there's something which is your, just a moment.
in 70 also in the village Kharvalli, where his mother's name appears with Qasur Ali, and Idris Ali is his elder brother.
Elder brother is not there out since 1970. Idris Ali.
So in 70, his elder brother's name is there. And elder brother's name against Qasur Ali is written, that is his their father. Petitioner,
On this, because of the fact that in the, there's a document Jamabandi,
Yes.
Exhibit 7.
Yes.
Exhibit 7, the entry is of 2019. The name of the brother is recorded.
in exhibit
Exhibit 7.
7, page 23.
Your brother's name Idris Ali is there. But his presence is not there anywhere else.
No, his name is also there. Page 24, kindly see. Idris Ali, then Sher Ali.
No, Sher Ali, we are not doubting. We are not asking a question on Sher Ali. We are trying to link it. Your brother's presence is not there except for this document.
So linkage is also there because in the police verification report, form 1, kindly see. Form 1 in the LCR. Now, Form 1 of the police prohibition report, kindly see. Here, Form 1, name of the person Muhammad Sher Ali, father's name Qasir Ali. So, the voters list are also in the name of Qasir Ali, and reference is against Sher Ali. So, Sher Ali's name is written as son of Qasir Ali. So, this is the starting point of initiation of this proceeding. Now, if the Qasir Ali is not accepted as the father of the petitioner, then this proceeding is also false. This Form 1 of the police reference. Here, can you see the name Sher Ali, son of Qasir Ali? So, if Qasir Ali is taken as the father of petitioner, and the voter list also bears the same name, and village is same. Village is also same. In the police proceeding report, address is given as Kharballi. What we are saying? Kharballi village. Kharballi is given. Now, all the voter list of 1966, 70, 85, 89, 20, 2017, all are the voter list of the same village, Kharballi. Now, Jamabandi, in the Jamabandi also, that is page 23, operating portion page 24, here the name of Sher Ali, son of Qasir Ali is written. Is at page 31. Evidence of petitioner Sher Ali, page 37. Page 37. Let me read the evidence, page 37. My parents were born at village Kharballi under Kolgasia PS. His parents are also born in the same village. Their names are recorded in the voter list of 66. Mother's name is recorded in the voter list of 70, along with the name of my elder brother Idris Ali. Lal Banu is wife of Idris Ali. I had cast my first vote in the year 1985, but I do not know my age in that year. I have been casting my vote regularly since then till today, to date. My name has been reflected in the land document and Jamabandi recorded in village Kharballi, height patta number 219, dag number 159, measuring 0 biga 2 gatha 10 lesa, situated at village Kharballi. I have been issued with the voter ID also. I have 3 sons and 2 daughters. Sons Qasimuddin, Jahimuddin, Mohidul, daughters are Samirannasa, wife of it is vacant, Regida, wife of so-and-so. Sontali, so-and-so, Sontali, P.S. Boko. We are two brothers. Other one is Idris Ali, who is no more. Idris Ali is own brother. So Idris Ali was not there, no more. He died when he adduced evidence. So Idris Ali's son has adduced evidence. That is DW2. Let me see 42 page. Let me see page 42. Amjad Ali. DW2. This is DW2. I am the grandson of Qasir Ali. Basatan Naza was my grandmother. Perhaps at that time Basatan Naza also died. When he adduced evidence, his grandmother died. Their names are enrolled in the voter list of 1965 in the village Karbali under Zonia LSC, house number not known, serial number not known. Grandmother's name is recorded in the voter list of 1970. It is correct, whether that is exhibited. Along with the names of my parents. Sherali is my parental uncle. Sherali was the younger brother of my father. Sherali is voter of 1970 and is a regular voter since till to date. Sherali was 5 children. Father died 3 years before. My house is half kilometer from house of Sherali in village Karbali. Sher possesses land property Karbali jointly with his brother Idris Ali. But I do not know his dag number and Patna number. Sherali is a citizen of India by birth. Now this Amjad Ali is the son of Idris Ali. And Idris Ali is the elder brother of Sher Ali. And the proceeding is in the name of Sher Ali, son of Qasir Ali. And village is written as Karbali. So number of witness is not the matter. Matter is quality of the witness. So everything is, I think, coming to right direction. Now cross-examination, I have not furnished. Now, kindly again come to page 42. I have not furnished any common voter list with my father to prove my identity. I have submitted a voter ID card to prove my relation with my father, Idris Ali. It is not a fact that I am not a son of Idris Ali. It is not a fact that my identity is not proved. It is not a fact that my testimony is not supported with my documented evidence and they are not reliable. It is not a fact that Sher Ali came to Assam from Bangladesh after 25th March 1971. So, my lord, so far the cross part is concerned, there is no diminutions up to the extent only not correct, only suggestions are given, he has denied. And if they want to show that Sher Ali is not your father, I think this honor shifts to them. I have said Idris Ali is my father, and if they say no, yet father, but he has said that I have submitted the voter ID to prove my relation with my father Idris Ali. So here another thing Lordship would see, page 25. It is the voter ID card of petitioner, Sher Ali, relation Sher Ali. Date of birth 78 years. So the Xerox copy is page 26. So here is also, it also proves the relation and linkage with Sher Ali. Now, for a moment, Lordship, I invite your Lordships kindly come to page 29. Page 29, bottom, from top 10 lines above. Apart from these documents, certain other letter documents have also been produced, including photo identity cards issued by Election Commission of India and identity card issued to his brother, including voter list in which the appellant's name appears. Having gone through these documents, we are of the view that it is not possible to state that Kamatullah is not the same despite being named Kafatullah in some of the documents. That being so, the grandfather's identity, father's identity, etc. has been established successfully by the appellant. Further, the mere fact that father may later have gone to another village is no reason to doubt this document. So it is not our case because we are always in Kharwali. We therefore set aside the judgment of the High Court as well as the Foreigners Tribunal and allow the appeal. As a result thereof, the appellant is liable to be set free at once. So the Honorable Supreme,
Evidence.
yes,
How many brothers this Sher Ali has? How many brothers
Really
does
has,
Sher Ali?
yes, that let us go then page 37. Page 37, after 7 lines, kindly see. I have 3 sons, just 3 sons, daughters, no, that is
Brothers and sisters.
Brother.
of Sher Ali.
brother. I have been issued with voter ID cards. I have 3 sons. It is in deposition, it is not there. Let us go to then to WS phase 31. 31. page 32 onwards, can you see? Page 32, para 4. The second party had one elder brother, namely Idris Ali, expired, and the second party had two sisters, namely Kusiran, expired, Rafia Khatun, expired.
Then
And also-
please come to page 24. In page 24,
Yes,
last 4 entries.
yes.
First name I could not read, Idris Ali. I think it is Idris Ali, son of Qasir Ali.
Mm.
He's the first brother. Then Sher Ali, son of Qasir Ali.
Mm.
Number
Mhm.
2, last entry is Abdul Jalil, son of Qasir Ali, 3. So we get 3 brothers from the Jama Mandi. It is there are 2 brothers.
Yes, this is, it appears so. Idris Ali,
Your documents are borrowed documents.
Sher Ali, and
You are taking advantage of similar name and borrowing documents from here and there.
no,
Your brothers,
No, there are so, in one patra, the names of many persons may be there.
no,
But here,
this is not there. You see, because you are not reading and are making a submission, and I am reading and asking questions. You will read first entry in page 24, first remark.
yes,
Premium was paid and the land was, pata was created in their name. This is serial number 1, 2, 3, 4. It's not a case where others' name are there. If others' name are there, that means other Sher Ali is also there. And you are borrowing documents.
my lord, it is actually in page 24, right side, the Sher Ali's name I do not see. But whether she has any say here, because the issuing authority is the circle officer. Now they have now written how my name came here. Father's name they have written. It should have been recorded as per.
Then you use your land, we tell the state to take over your land if that is not recorded, because this is by payment of premium. You can't disown your own land. In a foreigner's case, you can't disown your name in the, in that land, because then your land goes. You'll record that you don't own this land.
No, even then it should have been recorded in
Why?
one.
What is the necessity? This is not a document of title. The document by which by the state government issuing you the precept of the land in your name. That constitutes a document of title.
It is lands,
The allotment order becomes the document of title.
in the top it is written land records, computerization projects.
So that's why please don't question this document, because if you question it, we'll raise that question to the appropriate authority. We are not the ones to answer.
No, that is not there. What can I do? That is not there, but it should have been recorded.
But no. How does it matter? We are not discussing your title. We are discussing your brother, presence of your brother whose evidence is not there.
No,
How can the third brother come?
only his nephew has come.
There's also a third brother, which is not needed.
But it is an exhibited document, that is exhibit 7.
Mr. Mahmood, this is not expected from you. Can we exhibit this, Mr. Mahmood, can we exhibit this book and tell that the law is here, please find out? Once the book is exhibited, that means the court's duty to find out from these 800 pages as to what law you are referring to.
No, actually, my lord, I also asked how their names came. That is not written there. I have seen that. But what other I can do, because the record is like that. But apart from that, if your lordship do not believe it as the legal document.
I'm not saying I'm not believing it or not. I have not expressed our opinion. We are just asking questions.
But my answer is that is not there, my lord.
Asking of questions.
In note, there is not mentioning, no mention that in the land has come in the
Let me
name.
ask you a specific question. Would you like the court not to ask you questions when you are
No,
answering?
no.
No, we are ready to do it.
But other
But
documents,
then you won't even know what will come from the court.
but other documents, my lord, if you, for a moment, we forget this document, other documents proof. And village is Kharwali. Police affairs is Kharwali.
That you have taken note of.
And Kosarali is my father everywhere. And police reference has also said that this Sherali's father is Kosarali. So, if one document is disbelieved or is not accepted, then other documents' value cannot be reduced. There is judgment of the Honorable Supreme Court. A person may have one document may be a little doubtful or, but other documents can be taken up for consideration. And more so when they have not raised any question regarding the authenticity of those documents. Now, these are the certified copies, exhibited documents. So, I think, my lord, though there is some lacuna in the Jamabandi, but other documents, in many cases, my lord, we see that different places are there. But here is a case where every document belongs to Kharwali. And his claim is that my parents also took birth at village Kharwali. I also took birth at village Kharwali. So, and they want documents, that is, if you will also kindly see again page 38, page 37 bottom, and page 38 top.
Yes.
Now, For a moment, I again invite your lordship, kindly come to page 37 bottom. Last line, it is not a fact that the land which is recorded in my name and in the name of my brother Idris Ali does not prove our nationality. So, if that be so, but I have other documents like voter list 66, 70, 85 with my father, and many other documents. Gaura's certificate is there, but Gaura is not examined. That's why I'm not urging that point. Now kindly come to page 47. Impugn order. Summary. 47 summary. From record, it appears that the OP had furnished the name of Kosarali of village Kharvali at the time of inquiry, projecting him as his father. OP's projected father Kosarali and his wife Basatan Nessa were deemed citizens of India as their names are found recorded in the voter list of 1966 in Assam. Exhibit 3, 4, 5, 6 are all post 25th March 1971 period documents pertaining to OP Sherali, his wife Procedural Nessa and their sons and daughters-in-laws, not Idris Ali and his wife Lal Bhanu. Exhibit 2 on the premises, Exhibit 1 and 2 stand rejected as their relevancy with regard to OP Sherali is not proved. How? Because I have claimed that Kosarali is my father, and police officer has recorded my father's name as Kosarali, village Kharvali. So it's still rejected. Learned tribunal cannot say like this, because when evidence is there, documents are there, not is rejected. Rejection must be with well-founded reasons. Now, so far, post 71 document, yes, a person may have post 71 documents if there is any reference, but his linkage should go before 71. And before 71, linkage has gone. Suppose a person who has taken birth in the year 1990, so his name may not be there in the year 1971. But he has to prove that, yes, my linkage is with my father or grandfather who have their names being recorded in 66 or 71. So in that view, the finding of the learned tribunal that it is rejected, and then 4, as a logical corollary of the 3 above of his claimed relationship with his projected father, Kosarali, his wife, from wife I will not get citizenship. So this is not at all relevant. Of his claimed place of birth with no pleadings on his date of birth is also not proved. But he is nearly 80 years of age. So his date of birth he may not say. But that does not mean that he is not the citizen of India. So the earliest recorded presence of OP in Assam was in 1985 at his 35 years of age. Right, Exhibit 3, which is a post 25th March 71 period document with no connection with the rejected Exhibits 1 and 2. In absence of documented evidence, the oral evidence of OPW1 and that of Amjad Ali due to recorded or not also stand rejected. So it is when one author person is saying, and where there is no counter cross on vital points, there may be a little difference in the cross-examination, but on vital points there is no cross-examination. So I think the burden under section 9 has been discharged by the petitioner, and more so when the burden of proof in such type of cases is preponderance, and probability. In that view, I could prove my relationship with Kosarali, whose name is in the year 1966 voter list. My mother, Basatar Nasa, whose name is both in the voter list of 66 and 70. And later on, my nephew has also adduced evidence that I am the son of Idris Ali, who is the elder brother of Sher Ali petitioner. So, there is no any cogent objection on their part that no, you are not the son of Idris Ali. More so when he has said that the voter's ID card of a petitioner is there along with the name of this petition. And police report also, if Kosarali is not accepted as my father, then entire case goes, because in reference Kosarali is there. Now, if reference is accepted, then tribunal should have also accepted that yes, Kosarali is his father. In one time, you will reject that Kosarali is not my father, whereas your police said that Kosarali is his father. So you cannot take both the two lines, two types. You must be confined into one area. You cannot go to south and north at one time. Either go to south or north. So police report, I am okay. In my 66 voter list, I am okay. Now only because my name do not figure before 71 voter list, I am not a foreigner. I should not be declared as a foreigner. And in this regard, the ratio of that Sirajul Haq's case, that barely some documents say otherwise, as my lordship pointed out that Jamabandi or the land document, if we forget the land document, even then the other documents will prove that I am the son of Kosarali and who is a citizen. Planet Tribunal has also said Kosarali and Vasatar Nasa is a citizen of India. It has accepted. So my also plea that I being the son of Vasatar Nasa and Kosarali, that should have been accepted. The Honorable Supreme Court has said in one judgment, I remember, a person may have several defense points. If one or two defense points go, even then the other defense points, if acceptable otherwise, the benefit should be given to them. That's my humble prayer.
Yes.
Question. Yes. Tak pernah tu orang murid kalau lagi itu mesti ekor orang latest kau tu buat ni ekor.
Yes.
Lordship, your lordship, in this case, lordship, only thing that lordship petitioner has to establish his link with his projected father, Kasar Ali, lordship. And my humble submission is that petitioner is totally failed to establish his link with the person whose name reflected in the voter list of 1966 or 1971 lordship.
Sorry.
And lordship,
60 years.
one Amjad Ali has reduced evidence here, lordship,
60 years.
projecting himself as nephew of the Proceeding lordship. And
2004.
here, lordship, Amjad Ali also totally failed to establish his link with the person whose name reflected in the voter list of 1971, that is Idris Ali, lordship. And he only documentary evidence the only document he has submitted before the tribunal is voter ID card, which is not sufficient to prove one's linkage
My lord, with your lordship's kind permission, it appears that he appears now 82 years as per record. I don't know whether he's living or died, so at least I should have a information whether he is alive or dead. So that I keep open. Recently, I have no contact with him.
So lordship here, only document Amjad Ali placed before the tribunal is voter ID. Lordship, and this is not sufficient to prove one citizenship, lordship. Apart from that, lordship, 1966 to after 1971 to 1985, lordship, there is a gap of 15 years, lordship. So, lordship, there is a lack of continuous stay of the proceeding in the territory of India, lordship. And lordship has already pointed out in Jamabandi, there are 3 brothers, including 3 sons of Kasser Ali, lordship, but where in pleadings there is only 2 brothers of Kasser Ali, lordship. Lordship has already pointed out. And law is well settled that one cannot go beyond pleadings, lordship. And here, lordship, only things remains is that voters list, lordship, which is not sufficient to prove that he is a citizen of India, lordship. And lordship, in this regard, lordship, I want to rely on a decision of this honorable court, lordship, 2023 for GLT 246. Connected WBC number is 2370/2023. Aziz Mia. AZIZ MIYA. Para 14, lordship, I am relying. Just I am reading. Lordship, reported case, lordship, 2023 for GLT 246. 246, lordship. 2023 for GLT 246 and connected WPC is 2370/2023. Aziz Mia, AZIZ MIYA. Alias Muhammad Aziz Mia, MD full stop AZIZ MIA. Lordship, what para 14 has said, lordship, I am just reading para 14. We are constrained to observe that mere claim by a suspected person by referring to a voter's list, claiming a person therein to be his father is not a conclusive proof, and that by doing so the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voter's list relied upon this actually the father of the person who makes the claim will have to be substantiated with further materials acceptable in law. So, lordship, in this case, lordship, proceeding has lack of such materials by which he can substantiate his claim that he is the son of Kasser Ali, whose name reflected in the voter list of 1966. Another important aspect is that, lordship, a proceeding's name first time reflected in the voter list of 1985, and lordship has already pointed out if at that time his age was 35 years. If he is 35 years in 1985, he is sometimes born in the year of 1950. Then his first voting rights should be from the year 1971. But he could collect the voter list of Idris Ali, his elder brother, but he failed to collect the voter list, his own voter list, lordship, by where his name reflected lordship. So, lordship, this My humble submission is their lordship, these documents are procured by the proceedee from here and their lordship, and by which he can want to establish his claim that he is a citizen of India. So lordship, ultimately lordship, my humble submission is that lordship, there is no infirmity in the opinion passed by the learned tribunal, so opinion may not be disturbed, lordship. That's all.
Got one little answer. My learned friend said 3 brothers and 2 brothers. Perhaps at the time of writing the WS, one brother perhaps died, that is why it may be. Otherwise, no person forget the name of his own brothers. That is a presumption. And regarding this, he has collected here and there. My learned friend has said that he has collected some documents from here and there. That is not their case in the tribunal. There is a new submission before the Honorable High Court.
And Irazul Hawk's case is on different thing, lordship. It is not applicable in this case, lordship.
And my learned friend has shown one judgment. There is a contradictory judgment also. That's why some judgments should have been referred to larger bench or full bench. I think in the appropriate case, I will submit this because some judgments are contradictory. Division bench judgment is also contradictory on some points. I will argue in the appropriate time manner.
Mr. Emil Babu, for the question and also for the respondent. Submissions are completed or reserved.
But Kharvalli is always there. That lordship kindly keep remembering. Kharvalli is always there. All right.
For motion item 20.
May please your lordship, kindly matter will be adjourned only for the day, lordship.
Just now. without requiring any steps to be taken. Next paragraph. This is the matter for hearing in the week commencing.
Obliged Lordship.
Item 21.
Non-refusal of all the petitioner, all the respondents are presented. Next paragraph. For the bench of justice, the matter stand today. This way, give the petitioner remains action from follow of the inspector of listing. For my advice, photo. Next, list again on. 18th of May.
Item 22.
With the Lordship. Lordship, the opinion is the page 46, Lordship. The petitioner, she was declared as a foreigner, Lordship. Thereafter, she approached this honorable court. The opinion, the High Court judgment is a page 51, Lordship.
Yes.
Lordship, and this honorable court. And this honorable court, Lordship, remanded back the matter. That is at page, Lordship, page 53, Lordship. For the purpose we deem it appropriate. In order to establish a link with Taleb Ali Moral, the petitioner exhibited a certificate from Gaupura of Put Dharamtun Kisam, certifying that the petitioner is the daughter of Taleb Ali. The Gaupura has deposed himself as DW2, wherein it is stated that he was aged about 48 years. In his deposition, he stated that he was born and brought up in village Put Dharamtul, and his father also the Gaupura of Put Dharamtul, and that he knows the petitioner since about 30-40 years, and that the petitioner is presently about 50 years. He also deposed that her father is late Taleb Ali and mother Joygun Nessa. We have taken note of that DW2 is 48 years and the petitioner is 50 years. And therefore, for him to know the petitioner for the last 30 to 40 years would mean that he had known her since his age about 10 to 20 years. The said statement may either be believable or unbelievable, depending upon the circumstances under which the DW2 had his knowledge about the petitioner. For the purpose, we deem it appropriate that if the DW is subjected to cross-examination by the state authorities in order to arrive at a detailed examination as regards the correctness of his statement, that the father of the petitioner is Taleb Ali Moral and his mother is Joygun Nessa, whose name appeared in the voter list of 1965 relating to village Bosundora. For the purpose, we remand the matter back to the Foreigners Tribunal number 1st Morigaon for a cross-examination of DW2, so that a detailed verification be made on the correctness and the veracity of the statement that he had made in his evidence. That the petitioner is the daughter of Taleb Ali and Joygun Nessa, whose name appeared in the voter list of 1966 of Bosundora. The petition shall appear before the Foreigners Tribunal number 1st Morigaon on 18/3/2019, and upon her appearance, the required cross-examination be done, and the reason order be passed within a period of 30 days thereto. Lordship, pursuant to this order, Lordship, the petitioner appeared before the tribunal. Lordship, that order is at page 54, Lordship, and Action 11. Lordship, kindly come to page 55, Lordship. In the absence of the government leader, this tribunal examined the DW2, namely Godram Medi, who is a government Gaupura village, Shilbhata, on 25/2019. Under the Lordship, and the cross is at page 58, Lordship. Lordship, cross-examination was done by the tribunal,
and not by the state authorities, which is not permissible, Lordship. On page 58, Lordship, that is the cross-examination of DW2, which is done by the tribunal. Lordship, I will like to rely on the judgment. Order of this Honorable Court, Lordship, which is WPC 4496/2018.
Yes, okay. Cross of DW1. No. Oh, yes, yes, no. This is, yes. Cross. Yes, yes. Okay, under 137 of Indian. The previously ordered it is cancelled. Was there another helpful? What is it? 2520. Yes, yes. DW2 cross. The case is state reasonable judgment. It's close. Close, close. Yes. Yes, yes. Yes, sir. DW. Yes, yes, sir. Yes. Not in 165.
Okay.
DW 1.2. Oh. Oh, yes, bro. What is it? 155. After that is 135. But after a month, he has frequency note of 155. But after a month or two, he has frequency note of 155. Yes, yes, sir. Yes, sir.
But this as last learned counsel for the petitioner and so also for the respondents. Next. Please. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has essayed the opinion dated 29/6/2019, passed by the learned member, page 54, asked by so-and-so in case number so-and-so, reference number so. By which the petitioner, namely so-and-so, but declared to be a foreigner or considered inhabitant. Next paragraph. The record reveals that the petitioner suffered an opinion dated 7/9/2018 in the same proceedings. And the said opinion dated 7/9/2018 was put to challenge before this court by filing WPC 7803 of 2018. And this court by order dated 13/2/2019 remanded the matter back to the said learned tribunal directing the said learned tribunal to subject DW2 for cross-examination. Full stop. Next paragraph. On remand, the DW2 comma, namely comma, program GODRAM, program Medi, comma, Gaura, a in charge Gaura of Shilbeta, SHILPHE. Appeared before the Learned Tribunal for his cross-examination on 25/2019. Next paragraph. From the record, it appears that on 25/2019, the Learned Tribunal has recorded the following order. Give a subparagraph for the order. First line is D full stop, W full stop 2, closed full stop. Next para, the case is kept reserved for judgment. Full stop. Next para. The record of proceedings disclose that the cross-examination of DW2 has been recorded under section 165 of the Evidence Act from 1872, which is found to be overwritten with section 137. However, the court is not very sure as to whether section 165 is overridden with section 137 or section 137 is overridden with section 137. Though the record of record of examination on 25/2019 indicates cross-examination of DW2, but in paragraph 3 of the adjourned opinion dated 26/9/2019, the Learned Tribunal has recorded as follows. Take a subparagraph. In the absence of the government GOVT, full stop, leader, this tribunal examined the DW2, namely Godram, GODRAM, Godram Medhi, who is government Gaura, GOVT, full stop, Gaura, GAONBURA. of village Shilbheta on 25/2019 under section 165 of the Indian Evidence Act from 1872 in pursuance to the Honorable High Court order, dated DTP, full stop, 13-02-2019 in W, full stop P, full stop C, within bracket C, bracket was number 7803 of 2018. The order of proceedings. Disclose cross-examination of DW2 irrespective of use of section 137 and or 165 of the Evidence Act. But the use of the term cross-examination of DW2 is found to initiate the examination of DW2. Next one. The tribunal would have power under section 165 of the Evidence Act put questions to the witness, but the tribunal cannot down DAWN, down the count of prosecutor to cross-examine a witness produced by the proceedee. Moreover, the order sheet is not very clear as to whether the DW2 was cross-examined or questions under section 165 of the Evidence Act. Or there being overwriting and or overlapping of section 165 with section 137 of the Evidence Act. Next, this use of the term cross-examination in the proceedings of 25/2019, where according the queries put to DW2, police of the consider opinion that the matter calls for a remand for fresh recording of cross-examination of DW2. Next, in order to facilitate fresh cross-examination of the opinion dated 29/6/2019, page 54 is set aside. Next, Next para. It will be appropriate to quote paragraph 9 of the order dated 13/2/2019 passed by this court in WBC 7803 of 2018. This is at page 53. That's from the above, it appears that the direction was that the DW2 was to be subjected to cross-examination by the state authority. So accordingly, the learned tribunal is directed to subject DW to issue notice on DW2 for his appearance on a date to be fixed by the learned tribunal, and on appearance of DW2, the tribunal is required to comply with directions contained in paragraph 9 of the order dated 13/2/2019, passed in WBC 7803 of 2018. In order to facilitate, so that we have already stated, no? Set aside. The petitioner, who is duly represented by a learned counsel, is directed to appear before the said learned tribunal on 30 May 20. Saturday is a working day for them. No, all Saturday no. Second, third. That is fifth. Oh, okay. This is working day. Working day. 30, 5/26. And we are producing a certified copy of the order. For further orders to be passed by the said learned tribunal. The previous said that this is vitiated, is set aside. The recording of cross-examination by the learned tribunal also stands expunged. That the registry shall demand send back the tribunal's records as expeditious as possible. Next paper, the learned tribunal for the FT and border matters shall transmit a copy of this order to the Home and Political Department for the record. The question stands allowed to the extent as indicated, or partly allowed to the extent as indicated. If GP is not available, then the tribunal will do
If GP is not available, Lordship, then tribunal will do the needful, Lordship.
The state will have to do something.
Yes,
Because
yes,
your tribunal cannot be allowed to cross this.
Yes, yes, Lordship. So 165,
You will have to ask for modification of that order of paragraph 9.
yes,
You will have to ask for modification of that order.
yes,
Can't modify that order, that's not.
yes,
allowed.
Lordship.
If it is not available.
Then, yes, Lordship.
Without a government figure, how can you run the tribunal? It's unfair on part of the tribunal.
Perhaps now it is available, Lordship. Perhaps at that time, it, no, no, GP.
You get information and tell us tomorrow morning at 10:20.
Lordship.
If what 10:30 we not sign the order.
Yes, yes, Lord. Hey, Lordship, just now I can tell the court master.
We'll take care of it.
SGP.
Will be next item, 23.
My lordship.
Here's 23.
23.
Here's a call for the petitioner, how all the respondents are represented. For range of justice, the matters was adjourned today. List on. Oh, you are there. Yes. Sir Sharma, here there appears to be a wrong interpretation. You have to examine it. We'll take it up day after tomorrow. We could not read the. We are reading the English translation. We have not read the written statement. You have the copy of the petition.
Yes, yes.
Come to page 17A.
Yes, okay.
In 17A, please mark. Paragraph 10.
Then there is a bank in the memo.
Correct. Now, please come to the finding of the tribunal. That page 33. Last 5 lines. It is not, has not been created by the proceeding in his WS that he came from the proceeding comes to his father had land in his
Yes,
name.
yes, yes. Lordship.
Please examine that aspect because there's the SMS version is here at page 17B. Did not have time to read that, compare it. Take it up day after tomorrow.
No, not May, thereafter. First week of May.
Huh?
May, first week of May. First week of May.
First week of May.
Yes, sir.
First week of May is
Then thereafter.
first week of May. First day is Good Friday. Next day is Saturday. Saturday we can fix.
Second week, my lord.
Second is working.
Second week, my lord.
No, second day. You want first week, we don't disappoint you.
I have some problem in one way.
Process is represented. For the clear made by the counsel for the petitioner, the matter stands adjourned today. List on 11/5/2026.
Item 25.
Is 2019 matter.
Lordship, yes.
Okay, we had to adjourn it on the last date. We'll take it up tomorrow because we have a meeting. That's why we have to stand up. And listing it tomorrow. Both sides are represented. The possible time matter to what is taken up today. List in the motion column on. Make it.
Lordship.
Other matters would be adjourned.
Item number 41. Maybe fix at second week of March.
Fix it.
Item 42, your
May-
lordship, in Saturday, your lordship, this Saturday. Saturday. Saturday, fifth, Thursday,
be obliged.
Well, 48 and 49 Lordship can take there. 48 and 49 Lordship. I have mentioned at morning Lordship. There is no interim Lordship. Second time also. In second. Most of